All right. All right. I think I got a quorum here. Kay, will you please call the roll?
Representative Crago.
Here.
Representative Larson. He's right there.
He's just outside the door.
Yeah.
Circle back.
Representative Oakley.
Here.
Representative Provenza.
Here.
Representative Williams. Vice Chairman Washut.
Here.
Representative Yin.
Here.
Representative Swanitzer.
Excused.
Excused. Chairman Olson.
Here. Representative Larson is
Here.
here.
Yes, I had talked to him.
Representative Williams is excused.
Okay, thank you. Mr. Chairman, you have 7 in attendance and 2 excused.
Very good. All right. Senator, welcome back.
Good afternoon, House Judiciary Committee. Great to see you again. It's Friday. Feels like Friday, even though it's a 3-day week. So good House members, you have in front of you Senate File 124, which is Defending Wyoming Business Trade and Commerce Amendments. You know, the bill was originally titled Trade and Commerce Amendments, and I thought, that's not quite good enough. That sounds pretty boring. So we'll have to beef it up a little bit, and you'll get that pun here in a minute for why I added Defending Wyoming Business. Good representatives, what this bill does is primarily 2 things, and I'll explain why it's in front of you today and walk through the bill more carefully. This bill does, the first thing it does is it empowers our Attorney General to have civil enforcement authority over businesses operating in our state, particularly as it relates to antitrust concerns. And so that's the first section of the bill, and you can see that starting on page 2 for those civil investigations. The second thing that the bill does is it refines and hones in the criminal penalties associated with violating our antitrust laws in the state of Wyoming. And so those are the 2 primary things that the bill does. The reason for the bill really has to do with defending our Wyoming businesses as it relates to our agricultural industry and heavily influenced by our beef industry. As we saw really come fever pitch in 2020 during the pandemic, a food shortage, and you remember hearing about a meat shortage. Well, there was a lot of conversation and talk as to why that was occurring and the prices surrounding beef prices. And many of the attorney generals in the Western United States and the Rocky Mountain region felt that there was antitrust and anti-competitive practices occurring with the meat packers, who really control the beef industry in the United States. There's 4 primary, and they control 80% of that market. So it's really kind of an unacceptable situation that's occurring. So the attorney generals joined together and tried to take some action against some of those meat packers who it was believed were taking those anti-competitive practices in order to gain control and profit from that conduct. So some of the things that they did that affected Wyoming meat producers pretty directly was concerns about the closing of some of the meat processing plants in northern Colorado, where a lot of our beef production is transferred to and sold to, that those closures were not made sincerely or authentically as a result of a lack of supply or demand, that they were closed intentionally for the purpose of manipulating the markets. This has been going on since really about 2015. And again, like I said, reached fever pitch in 2020. In Wyoming, we went ahead and looked at our laws with the executive branch being greatly concerned about how this affects our economy and our Wyoming businesses. Our number 3 revenue production really is the ag industry, and beef producers being one of those, primary one of those. Recognized we had pretty weak laws associated with the ability to investigate both on the civil front and then enforce on the criminal front. And so working collaboratively with the executive branch to refine and enhance to ensure that Wyoming's businesses related to all of them, but as it relates to the immediate need for this bill, our ag producers those protections to defend Wyoming business and the economy. Stand for any questions, Mr. Chairman? If not, I can walk through the bill more carefully.
Yeah, let's just walk through the bill unless anybody has any questions on the introduction. Nope.
Some neat history. I don't know what your agenda looks like, Mr. Chairman, so let me know if I'm need to
You're
be
it.
briefer.
You want to give us a neat history? Go ahead.
Wonderful. Not exactly beef history, but related to antitrust. So, which is what kind of, I think, notable. Antitrust has been around for a long time, and antitrust really means anti-monopolies, right? So when a corporation becomes too large that they manipulate the market, so there can't be fair competition in a capitalist society, which of course is fundamental to the United States. The Sherman Act was the foundational federal law that was enacted in 1890, the same time we became a state. And much of the law that you're reading today and currently found in our Consumer Protection Act, Antitrust Act, is really related to that time period and is very similarly written. At that time, what were those companies that were really dominating our industries? Railroad being a prime factor with that. And so uniquely here in Cheyenne, where our capital is located, when you look down and you look south from our front steps of our capital, what is it that you see? You see the depot. And the reason for that is that is not coincidence, but rather as a need for the capital to keep a close eye on the railroad, because at that time, really the railroad was more powerful than any state legislature and potentially more powerful than Washington, D.C. So we recognize the power that big business can have and corporate America, and how wonderful that is to see those businesses grow and develop, but sometimes a little balance and a little regulation needs to occur in order to have a thriving economy. So some fun history there. With that, I'll walk through the bill. So starting on page 2, as indicated, civil investigations by the Attorney General. So whenever the Attorney General has probable cause to believe that any person, firm, corporation, or other entity, whether foreign or domestic, has engaged in, and I'm not going to read you the bill, but I'm going to go through this briefly, has engaged in or is engaging in a violation of any provision of this act or any provision of federal antitrust law, so really important there, that may be enforced by the Attorney General. The Attorney General may, so there's no mandate, may initiate an investigation. As part of any investigation under this section, the Attorney General may administer oaths and affirmations, subpoena witnesses, documents, or other matters, propound interrogatories to be answered in writing under oath, and collect evidence. And so what that really is, those are tools in a civil case that civil attorneys use regularly in any kind of, it's called discovery in the criminals in the legal system. And so those are tools at the toolbox that we are giving the Attorney General to use in order to determine whether or not there is a violation of law that may be occurring.
Senator. So, and maybe just kind of thumbing through, but I'm not, so you're not providing a avenue for just a private citizen, an individual to bring an action. Other than they could bring it to the Attorney General's attention, I suppose.
Mr. Chairman, that's correct. And this is really in the antitrust provision. In our Consumer Protection Act, there is an opportunity for citizens to bring a private right of action, but that's probably somewhat doubtful here with an antitrust case. For example, Joe Citizen suing Cargill, or that it's probably more appropriately placed with the Attorney General representing all of the industries in Wyoming.
Representative Washington.
Thank you, Mr. Chairman. Senator, could you elaborate a little bit more about the authority of the Attorney General to deal with foreign and domestic, and whether it's interstate commerce and how that might play into this type of decision?
Certainly, Mr. Chairman, through you, Representative Washit, we cannot bestow federal powers. There are laws that allow for long arm statutes for the Attorney General that if there is, if that business is doing business with the state of Wyoming in some fashion, is touching our state, the jurisdiction is there. So certainly the Attorney General, this law does not expand the jurisdiction of the state of Wyoming, and this is still a state enterprise and with those limitations involved. of note, and I think importantly to recognize for how that works, I think on the ground is that most commonly the attorneys general don't work by themselves. They really work more as a team, particularly when an action like this is taking place. And so they join together and collaborate and consolidate resources because those concerns aren't unique to the state of Wyoming quite commonly. So the ag producers in Nebraska and ag producers in Montana and Idaho and Colorado are both similarly affected. And so joining those resources, but making sure that our state can lead the charge if necessary or take individual action if necessary and effectively participate in that litigation with our similarly situated Western states. So with that, we'll keep moving through the bill. Going on to really page 3, Representative Washut, to kind of address your questions there. Line 13, Romanet C, and I'm just randomly kind of moving here through the bill. If any matter that the Attorney General seeks to obtain by subpoena is not located within Wyoming, there's your interstate commerce out of state jurisdiction issue, and is not reducible to electronic reproduction and transmission, the party subpoenaed may take the matter available to the Attorney General to examine the matter at the place where it is located, allowing the Attorney General to work with that limitation and provide some flexible options there for those industries. Moving through page 4, paragraph D, the Attorney General may apply to the district court for an order compelling compliance. So still, just because it's the Attorney General in a powerful position with many authorities, they still need court authorization to really force action. And so Attorney General still needs to go get the judge's approval for many of these actions, including a motion to compel or some type of requirement to produce documents. Again, this is in a civil arena, so this is not a criminal investigation. This is a civil investigation piece. Page 5, paragraph G. Any person who fails to appear with intent to avoid, evade, or prevent compliance in whole or in part with any investigation, who tries to falsify materials, avoid the purpose, they shall be liable for a civil penalty as provided in this subsection. The Attorney General, upon petition of the court, can recover $25,000 for each one of those. So that's really important. One piece that's commonly overlooked or maybe underappreciated for what the Attorney General's office can do and commonly does, particularly in the consumer protection realm. They litigate cases on behalf of the people of Wyoming, and sometimes that results in money recovery for the state. And this is another avenue where we could get money recovery for the state. So I wouldn't call it a revenue generator, but it certainly is more likely than not to indeed have that result. One common example that you're familiar with probably is our tobacco funds. So those are actually in statute. We receive a significant amount of funds from those tobacco lawsuit settlements. Every state in the country has, and that would be kind of an example of that you might be familiar with. So moving on to page 6, civil enforcement by the Attorney General. Moving on to page 7, going through the list of what the Attorney General is authorized to do in the civil action. Line 5, Romanet 1, obtain a declaratory judgment, which is simply a court decision that says a violation of law has occurred. 2, enjoin any action, which means stop it. So stop whatever illegal action is occurring from continuing to occur. Romanet 3, recover a civil penalty. So remember, if there's a violation of this law, it means Wyoming businesses have been harmed and damages should be provided. And so this provides that particular opportunity for that to take place. Line 18, obtain an order requiring divestiture of assets. And under what circumstance does that occur? That is found on line 21, that can occur if there was a violation of the law and that a court determines is necessary to avoid the creation or continuation of a monopoly right? So something lawful is occurring, we have to break it up, right? And that's how that really works. Line 5 on page 8, to restore the competition to Wyoming commerce, recover actual damages, all those very typical in a civil action. But just spells it out here that the authority of the Attorney General is very clear and has all of these tools in the toolbox. Page 9, line 17. In lieu of initiating or continuing an investigation or civil action, the Attorney General may accept and enter into a consent agreement with respect to any action or practice alleged to violate this act. Any consent agreement may include a stipulation for the payment of civil penalties, reimbursement of the Attorney General's reasonable expenses, costs, attorney fees, and the payment of restitution and actual damages for Wyoming residents, right? So that's pretty good. Which court has jurisdiction? It can be brought in the district court in the county in which the party resides, the principal place of business. All of this is pretty customary language. So moving on to page 11. What does this look like? What does anti-trade look like? What is a violation of this law? What conduct does a business have to do in order to be found in violation of that? That's really found on page 11. So any person, firm, corporation, foreign or domestic or other entity doing business in the state of Wyoming is prohibited from, essentially, shall not, make, enter into, form, or become a party to any plan, contract, agreement, conspiracy, asset acquisition, consolidation, merger, or combination of any kind whatsoever to prevent or substantially lessen competition, create a monopoly, or to control or influence production of prices thereof. So take note of the language that's being added as opposed to the language that currently exists, which is a very common language. Most states have this language. Again, it derives from the Sherman Act from 1890. So certainly nothing new in the United States. And the reason for these additional terms in there is really to hone in on some of the conduct that we've seen from these meat packers and to address what is happening in that industry. It's not limited to that, but as we understood what happened there and the concerns presented there, we realized it would probably be prudent for us to beef that up. All right, here's that second piece of the bill that I mentioned, page 12, that criminal enforcement and penalties. So again, when does it fall into the criminal piece as opposed to the civil piece? Any person, firm, corporation, or other entity violating any of the provisions shall be fined in any sum not more than $50,000. Again, we're talking about large corporations. $50,000 probably for these corporations is mere pocket change. And then on paragraph B, the district attorney may enforce criminal violations of this act against any person, firm, corporation, or entity. So if it's sufficient enough, the district attorney who is tasked and has taken the oath to prosecute crimes may proceed, pretty exciting, with pursuing these types of actions. Corporations can be found guilty of crimes as well. The remainder of the bill addresses car dealerships. The bill does not deal with car dealerships. It's just making conforming amendments to this statutory section relating to car dealerships to be consistent with what we've done earlier in the bill. So don't let that be a distraction to you. It really is just conforming amendments consistent with the previous portions of the bill. That's the bill. I do believe that there might be some public comment from members of industry and from members of the executive branch who may want to provide opinion on the bill.
Representative Oakley.
Thank you, Mr. Chair. Thank you, Senator Nethercutt. Real quick, my question is just about the word monopoly. If there's been any discussion about if that's too narrow, and I'm just going off of sort of common knowledge or my thought that relates to one company, and like even our discussion has been meat packers. So I don't know if oligopoly. I don't know. I just was wondering if there's any discussion on that. If possibly if the word monopoly is too narrow.
Senator Nethercutt.
Mr. Chairman, thank you, Representative Oakley. Great question. I think it's probably okay. When we look at the conduct that really gets somebody into that space, there is that conspiracy component that would cover those pieces. And we know that it's a common practice of corporations to use multiple subsidiaries, but really it's one branch, right, of the large conglomerate. So a series LLC, just triggering interest in the bill, could serve as that. But commonly we have a number of corporations that we think that we're dealing with, Smith's grocery store or Albertson's grocery store, and we think that those are different grocery stores when in fact they're all one grocery store. And it's the same company that you are buying your groceries from in the same generic brand product, just with a different name to it. So there's the ability that's still a monopoly because they're acting in concert and together. Not saying that grocery stores are doing that, but that's an example of how we see that commonly happening in the United States. That just because you have a different corporate structure doesn't mean you won't be found to be guilty of having a monopoly if they are acting in concert in a conspiracy type fashion.
Vice Chairman Washit.
Thank you, Mr. Chairman. Senator, a little over a year ago, I spoke with a cattle producing organization in our state. And at that time, they told me that there was some litigation already in the works from, I think, a private side, or maybe you can enlighten us there. And I just want to make sure that this complements and doesn't compound.
Senator Nethercutt.
Mr. Chairman, it empowers. So there is private litigation. There is many states attorney generals moved forward with litigation, including Wyoming, both in reaching out to the Department of Justice and trying to take immediate action. Again, the power of these corporations is profound. They control 80% of the global market concerning this type of production. So in consultation with the subject matter experts concerning how do we empower both our own businesses to protect themselves and to be able to have a voice and to allow our state to defend those businesses as well, this is the consensus.
Representative Craigo.
Thank you, Mr. Chairman. Senator, mine's a sort of a technical question. So on page 2, you use the word probable cause. And later on in the bill, on page 6, you use the word reasonable cause on line 20. And I just bring that up because probable cause is technically a criminal term.
Mm-hmm.
And so I didn't know why we use 2 different terms or
Yeah.
if there was a reason for that.
Mr. Chairman, no, there is no reason for that. And a great catch. And I would entertain an amendment to make those conforming in whatever fashion the committee finds appropriate.
Okay.
I would say, thinking about that through, Mr. Chairman, if I may, is to keep it probable, even though it's a criminal term, because this action can become criminal. I think that that's reasonable to have it be that the standard for the Attorney General should be more likely than not that a violation of law is occurring, thus to trigger the civil enforcement tools probably is the best course. So I would suggest on page 6 to change that to probable.
To that point, where does this bill come from? Is it modeled after something, or where did we take these statutes from?
Our own statutes,
Okay.
other state statutes, federal codes as well.
Just trying to understand, maybe there's a genesis to the whether it's probable cause or reasonable cause. But 2, if there is a reason for it's not just a typographical error, but if these are statutes that we're modeling after, or maybe they're lifted from completely different jurisdictions.
Mr. Chairman, great question. Was there wisdom in leaving one reasonable and one probable? I can't speak to that. I'm not certain those pieces, but just using my own good sense, I don't know that it necessarily matters in reality on the ground. So if I'm looking at page 6, civil enforcement, does it matter? Does it change my analysis or whether or not I reach the threshold of whether or not I can seek declaratory judgment? If I have probable cause, the Attorney General or reasonable cause would not move forward without either, with litigation against a large corporation to make a judicial determination. Does that make sense?
Representative Craig.
Because it's not like it can be suppressed, right? It's not because it's not being used in a criminal context. So the civil action can't be dismissed because reasonable cause or probable cause doesn't exist, right? That's not the basis for the action to take place. And the rules of civil procedure would trigger.
Mr. Chairman,
Please.
I agree with the senator. I would prefer we use the word reasonable just to take us out of the realm of criminal law, because just whenever I hear the word probable, the first thing I think of is criminal. And this particular procedure we're talking about in that part of the bill is strictly civil. But as far as what is the level of proof, I would agree it's the same under both words. It's just the connotation of what it brings my mind to. And if there would possibly be some sort of defense at that point on behalf of the quote unquote defendant or the person being in company person being investigated, that we would not want to confer on them at that point by using the word probable. That was my only concern, but I do totally agree. The level of proof is going to be the same from our side as the state.
Mr. Chairman, I do believe the Attorney General's office is present online, so.
Yeah, we can certainly ask them. Before we go there though, and this, I may follow up. My questions may be for them, but I'll shoot them at you. I'll try. I'm looking at the budget. So the first question is, and again, the Attorney General's office may answer this for me, but does the are there existing personnel expertise ready to meet a litigation need? I don't know when this goes into effect, July 1?
Mr. Chairman, great question. This is not demanding litigation, and we've already been a part of it. What we're doing is we're providing more tools to the attorneys general who are working on the issue already. So I think that's important to recognize. So it's my understanding that they have the capacity and the competency to move forward with it. They're doing it now.
Well,
they recover significant
Senator,
funds for us.
You're going to get to the capacity question because that's not true, because they're asking for an additional attorney. But to the competency question.
Who isn't?
Yeah, right. Oh, so I just want to make sure what I'm asking, Senator, is they're asking for another attorney.
No.
And what's that?
In this bill?
In your agency impact statement. I don't know if you've had a chance to look at that.
There's a new fiscal note on the bill.
Well, this is the agency impact statement. So what it does, I was curious because this would potentially go two ways. It would either go with an increase to the 900 series, which would be contracting out to a private firm, or it would go internally. And it looks like they've chosen the 900 series is just an expert witnesses. The 100 series increase is an attorney, paralegal, and investigator. And that's what I'm just trying to figure out whether that is because they don't have the expertise for the attorney they need, or it's because the manpower or woman power, excuse me, and would need an additional attorney. That's what I'm trying to figure out.
Thank you, Mr. Chairman. It is deeply disappointing that the Attorney General's office did try to do this. They provided a fiscal note originally on the bill. I reached out to them and asked them to remove that fiscal note because there's no mandate in the bill. It allows civil enforcement authority at the Attorney General's discretion. If the Attorney General doesn't feel like they have the expertise to do consumer protection and antitrust issues, that certainly is a fundamental question for us to ask the Attorney General's office. But I don't believe that this bill requires an additional attorney or some specialized expertise. And in fact, history has shown us from that office that they are able to move forward.
I will take those questions to them, Senator.
I certainly would.
Thank you. Okay. All right. Don't go anywhere, Senator.
I'm sorry.
I said, don't go anywhere.
Oh, I'll be right here.
All right. Attorney General's office, we have them in Zoom. Ben, I believe.
Yes. And Mr. Chairman, I'll admit, Mr. Birmingham, I also have Emily Soley from the governor's office.
Okay. Let's let them both in at the same time, actually, because I suspect this agency impact statement will be relevant to both of them.
Okay, I've admitted them both.
All right. Welcome. Let's start with the Attorney General's office. Ben?
Yes, Mr. Chair, Ben Birmingham with the Wyoming Attorney General's office. I'm here today to confirm that my office has reviewed this legislation. We are comfortable with the legislation. We indeed are prepared and ready to implement this legislation. And without confirmation, I'd be happy to answer any questions that you may have. So I stand for questions.
Mr. Birmingham, my question is, where will this be in the Attorney General office? I'm assuming the Consumer Protection Division, or where does this end up?
Mr. Chair, you are correct. The Consumer Protection Unit of the Wyoming Attorney General's office enforces both our consumer protection statutes and our antitrust statutes. So that's where this work will go.
And my second question is, does the Attorney General's office have the expertise to say, call it a hypothetical or whatever you want, this bill goes into law and the Attorney General's office has a case in front of it and it makes sense to prosecute it. Does the Attorney General's office currently have the expertise to pursue an action under this bill?
Mr. Chair, I would unequivocally say yes. I think it's important to point out that while our state antitrust laws are lacking, we do have authority to enforce federal antitrust law. And that is something that we have done for several years. We're currently involved in litigation in the Eastern District of Pennsylvania against major generic drug makers, accusing them of antitrust violations, specifically price fixing of generic drug prices. We're also involved in litigation against Facebook and Google for Sherman Act Section 2 monopoly maintenance claims. So while we have little experience with state antitrust law, we do have experience with federal antitrust law, which is substantially similar, as Senator Nethercott has explained today. So we do have that in-house expertise and knowledge base to enforce these laws.
Mr. Birmingham, and the reason why I ask that is because the old appropriator in me looks at two series, 100 and 900. And the one thing I don't want this bill to become is in the future, a 900 series growth, where this bill is enacted into law. We have, even if it's one lawsuit, and the Attorney General's office returns to the Appropriations Committee and says, we don't have the expertise for this, so we're going to have to hire outside counsel. And that's where our budgets see a lot of growth in the 900 series. So I'm just trying to make sure that the only 900 series I see projected right now is expert witness. And I just want to make sure it's not going to result in outside counsel.
Mr. Chair,
And Senator Nethercott really wants to chime in. So maybe before you step into anything, I'll let Senator Nethercott.
Thank you, Mr. Chairman. Can you see me as a fifth grader? I know the answer. What I would like the Attorney General's office also to explain with that is, one, there is no fiscal note with this bill, and there is no need to add. But if they did, I think it's important to recognize how much money the state of Wyoming earns from these actions. And so if the Attorney General's office can maybe also provide the dollar amount that it has recovered on behalf of Wyoming citizens in these actions, that would be most helpful.
Okay, Ben,
Yeah.
you want to start with whatever you want to address? I think they're both relevant questions.
Mr. Chair, certainly happy to. I think it's worth noting that our unit is a bit unique amongst state government agencies in that we are revenue generating and revenue self-sustaining.
Ben, you went really quiet.
Sorry, Mr. Chair, can you hear me now?
It's better.
Okay, I will speak up. So, Mr. Chair, what I was stating is that our agency is a bit unique in that we are both revenue generating and revenue self-sustaining. So through these settlements that we have reached in the consumer protection context, since 2018, we have obtained orders for a little over $11 million. And after those orders, we have recovered about $5.7 million in consumer refunds and payments to the state. And we have funded this litigation through the Consumer Protection Fund. And through this fund, we have paid for experts, paid for our litigation costs, and have successfully pursued these cases. And then from these cases, we have recovered attorney's fees and settlement payments for the state. So this work is actually generating funds, not costing funds.
Oh, good. It sounds like one day we'll be able to take the Consumer Protection Division off the general fund. So I appreciate those comments.
Mr. Chairman.
Representative Yin.
Thank you, Mr. Chairman. So, I was looking at that agency report or whatever it's called. And it said that these come out of the Consumer Protection Fund. Is that correct? So would any new positions hired in this unit come from that fund? And is that where the money that we collect go into?
Yeah, I think that's what the agency statement says.
Mr. Chairman, if I may. And poor Mr. Birmingham, I don't think he's actually the talent in the office that is litigating most of these cases on behalf of the people of Wyoming and is maybe less involved with some of the stuff that we do up here at the Capitol. I did see the request from the Attorney General's office for those additional 2 full-time positions. And although I have no personal knowledge, I can only speculate that as a result of that need and that request, there was an effort to jump onto this bill, I think inappropriately, as another avenue potentially to get some revenue for folks. I think that was inappropriate. And I think that was harmful to the bill, obviously, and has created a conversation on the bill that I don't think is appropriate or relevant. The bill doesn't require anyone to sue. It's still at the discretion of the Attorney General. If the Attorney General doesn't have the means or the ability, certainly they don't have to move forward, right? If they do think a cause of action is worthwhile and will generate revenue for the citizens, then that conversation can occur. But this bill and expanding civil enforcement authority with discovery tools does not mean we need employees, in that agency. Certainly that's a request they can make later, again, as I indicated, but I suspect that the bill was hijacked. And I'm not pleased.
Representative Oakley.
Thank you, Mr. Chair. Just quickly, the second to last sentence before the breakdown of the cost there says funding for any additional staffing would come from the Consumer Protection Fund, not the State General Fund. Anyway, so I think that's relevant to this discussion, although also recognition of what the good senator just said, which is maybe none of this is relevant to passing this bill.
Maybe we need to scoot Representative Oakley closer to Representative Yin. We just talked. Yep. Yes, indeed. Additional questions for the Attorney General? I'm sorry, Senator.
Mr. Chairman, do you want to address that probable reasonable question?
Oh, yes, actually, Ben, that is a question we have for you. I'm assuming you heard the exchange between the senator and Representative Crago regarding probable cause and reasonable cause. Do you have any insight?
Mr. Chair, happy to share the insight that I have, and that is the probable cause language here in our antitrust statute for an administrative or a civil investigative subpoena would be consistent with the language that we have in our State Consumer Protection Act. There, it also requires probable cause. There is case law and legal scholarship that recognizes the probable cause in the criminal context and in the civil investigative context is different. The Wyoming Supreme Court is currently taking up the issue of how do we define probable cause within our Consumer Protection Act. So we should be getting some guidance on that. But I think the largest point is, in practice, for us, the difference between probable cause and reasonable cause is really insignificant and meaningless. If there's concerns about probable cause having too much of a connotation with the criminal context, then I think certainly a friendly amendment changing it from probable cause to reasonable cause would be completely fine and acceptable to our office.
Okay. I like that answer. Additional questions for the Attorney General? Office. All right. Thanks, Ben. Let's move to the governor's office.
Chairman Olson, members of the committee, thank you so much for considering this today. My name is Emily Solai. I'm special counsel to the governor, and I won't repeat everything that Ben and Senator Nethercott have said. I'm really here to voice the governor's support for this bill. Of course, the governor supported or voiced his own support for this bill in his State of the State as something that is important as the state's economy recovers, which of course is in the forefront of all of our minds right now. We believe this bill is important for business, it's important for consumers, and it's important for all areas of industry in Wyoming, but specifically agriculture. As Senator Nethercott noted, kind of the impetus for this bill were some pricing issues and some asset acquisitions that occurred last year in the agriculture industry that we heard about from the ag community. And as we were looking at what could we do about that, ultimately all we could do was go to the feds and ask for them to initiate an investigation, go to other state partners and ask for them to initiate an investigation, but we could not go to our own Attorney General to ask for an investigation to be initiated because, unlike the Consumer Protection Statute, the antitrust statute currently does not provide pre-suit investigative authority to the Attorney General, which is absolutely critical for these antitrust cases. So that was really kind of the origin of this bill. It's incredibly important, again, to ensure a competitive marketplace in Wyoming, that the Attorney General have that authority, and also important that the Attorney General have the relief that is made available through this bill that is currently unavailable to the state as an enforcement. So with that, I would stand for questions. And I would actually, Mr. Chairman, I would like to address the Attorney General's capacity, if I may.
Please.
So, Mr. Chairman, just in an effort to kind of celebrate the Attorney General's office and specifically the Consumer Protection Division, Ben and his crew, Wyoming was one of a handful of states that civilly prosecuted the opioids matters on its own, did not hire outside counsel. Almost every other state did. But Wyoming, when it filed against Purdue Pharma, did not bring in outside counsel. So truly, they do have the capacity to work these cases. They currently work these cases alongside other states and the feds. Importantly, though, the only time they can do that now, as the statute is currently written, is if there's a consumer protection cause of action to go along with it. And so we really need this bill to move forward in order to have standalone antitrust cases, which is really what we find in the agriculture industry.
That is exactly what I wanted to hear. Because it's, you know, regardless of whether it's coming out of the general fund or the consumer protection fund, the reality is that those consumer protection fund dollars can be used for a lot of things. And if we didn't have the capacity and it resulted in a 900 series growth, as Senator Nethercott knows, those dollars are more expensive when you hire an outside firm almost always. And so if we can do it in-house, I think that's, I
Mr.
mean,
Chairman,
that's just great to hear.
Mr. Chairman, as you and I both know, self-sustaining law firms are the way to go. And certainly RAG's office has proven their ability to do that. If we could bring them back online potentially for a minute, I do believe recognizing the talent that was successful in effectuating successful opioid lawsuit litigation and bringing money in for Wyoming is really important by this legislature and potentially by this committee, recognizing how significant that was.
Okay.
One of
Thank
the most
you.
successful lawyers in our state.
Well, amen. All right. Thank you, Governor's office. Ben, did you leave us?
I'm here, Mr. Chair, if there are any further questions.
Well, Senator Nethercott would like to throw you a party.
We would like to give you a round of applause.
Well, thank you.
Thank you, Ben. All right. Committee, any questions for the Governor's office or the Attorney General's office? Nope. All right. Very good. Do we have additional public comment in the virtual world?
Mr. Chairman, we do have 2 additional people in the Zoom waiting room, one with his hand up. Shall I admit Jim Magagna?
Let's let Jim in.
Mr. Chairman, I also have Amy Hendrickson, I believe from the Wyoming Wool Growers Association.
All right. We'll do Jim on deck first and Amy second. Jim, welcome to the Judiciary Committee.
Thank you, Mr. Chairman. Appreciate the opportunity to visit with you briefly this afternoon. I believe that Senator Nethercott did a very good job of providing the background that was the impetus for bringing this legislation at this point in time. And we strongly endorse the legislation. There are just 2 points I would make for the benefit of the committee. The first is that while the scenario that evolved just about a year ago now with the COVID outbreak, when we saw the price of boxed beef double in the marketplace in a matter of about 2 weeks, and at the same time, the price that our producers were receiving on finished cattle dropped by 30%. That was a wake-up call for us as an industry. But I would emphasize that while that was the wake-up call, this monopoly type situation isn't something that just happened in 2020. This is something that has evolved over a relatively long history in our industry, as we've evolved from the local butcher shops to now the big 4 that process over 80% of our beef in the United States. So the need for legislation that enables the Attorney General's office to look at this existed prior to this point in time, and we believe will certainly exist moving on to the future. So I'm not saying that this legislation is passed, which we hope it will be, that means the following week, the process of filing litigation is going to begin. I'm sure that the Attorney General and we as an industry will look at when there's a most appropriate time to act on that. And it's going to be an ongoing problem for us. The other point that I think is critical, while we tend to look at this legislation in terms of the negative impact on our livestock industry in the state, both beef and lamb, as a result of what's happened, as is implied by the fact that this is housed in the consumer protections sector of the Attorney General's office. The consumers in Wyoming, as well as elsewhere across the country, were perhaps not as obviously, but very significantly impacted because of those increases in beef prices, which reached down to the retail level, where we saw, as an example, with the COVID outbreak, the demand became tremendous for ground beef as people were cooking more and more at home, and the prices of ground beef more than doubled in a short period of time. So My point is that Wyoming's in somewhat of a particularly strong position in utilizing legislation like this because the harm extends to both ends of the production and marketing cycle, the producer on one end and consumer on the other. With that, Mr. Chairman, I again appreciate your support for this and would be happy to entertain any questions.
Thank you, Jim. Vice Chairman Washut.
Thank you, Mr. Chairman. Mr. McGagnon, glad you're here with us today. As a city boy, I think I have an idea of how this market gets manipulated. But could you explain just a little bit how that impacts the producer and what limitations it creates in terms of price for your product?
Mr. Chairman, Representative Washut, yes, and when we say the producer, I think it's important that we look at all of the levels in the production cycle. The dramatic price decline that I mentioned earlier, that occurred on finished cattle, which are primarily cattle coming out of a feedlot where they've been finished for processing. We don't have a lot of that in Wyoming. We have some, but then that filters down the cycle. Because the feeders took those large losses, then they were put in a position of having to go out and buy pasture cattle to put into their feedlots at lower prices. That then comes back down to the cow-calf producer. I would say, in being fully transparent about this, while if we were talking about this in March or April or May last year, we looked like 2020 was going to be an incredible disaster for our cattle producers in Wyoming. As it turned out, because there was a strong demand and as the processing began to pick back up somewhat, in spite of those price differentials, the price back for the cattle that are mostly being marketed in Wyoming picked up significantly. And with some help from the Federal CARES Act, in addition, our producers, for the most part, had a reasonable year, not a profitable year, but a reasonable year in the state. But because of the various steps in that cycle, it can affect us in different ways. The seasonality of when it happens is critically important, given that the majority of the cattle in Wyoming are marketed in the fall season. I hope that's helpful to your question, Representative.
Yes, it was. Thank you very much, Mr. McGagnon.
All right, thank you, Jim. Further questions for the stock growers? All right, let's move to the wool growers. Amy, welcome.
Thank you, Mr. Chairman. Amy Hendrickson, the Wyoming Wool Growers Association, and we are in support of this legislation. A year ago, we had, when the shutdowns happened, some of you may have known this, that the second largest lamb plant in the United States, which was owned by a Wyoming company, was forced into bankruptcy, and it meant a loss of capacity that was just devastating to our prices. We were experiencing some of the highest prices that we had seen, and within 2 weeks, those prices were had dropped more than half. And where there was some need to do some investigation. The state really wanted to assist us in this, and they simply were not able to. And so it doesn't do anything for that situation now, but it would help in the future for any company that would run into a similar situation. And for that reason, we also experienced quite a lot of what Mr. McGagnon was discussing, but lamb is a premium product anyway. Our retail prices are substantially higher than beef prices, and so we are very sensitive to any changes in the market for that reason. And with that, I will accept any questions and again just reiterate our support for this legislation.
Committee, questions? Amy, I have a completely unrelated question to this bill, which is, is your association been involved at all with the project at University of Wyoming to put wool on a blockchain?
Yes, peripherally, that has been, certainly we've worked closely with Stuart, the sheep specialist there. But yes, we're very enthusiastic about that project.
Yeah, I'm pretty excited about that. It's a pretty cool project. Going to put wool on the chain, track it all the way to the final product, blanket, or I think it's a blanket, but it could be a parka or whatever it is, and scan it back to source. And then eventually we'll be meat producing as well, I assume.
Yes, Mr. Chairman, we've already done some work on the blockchain it's called sheep chain.
Sheep chain.
There.
Sheep chain. Sure, go ahead.
Thank you, Mr. Chairman. Mr. McGagnon, you mentioned that we didn't have a lot of feedlots in Wyoming. Is that because we don't raise much corn in Wyoming? Or is there some other reason why we don't finish our cattle here in our own state?
Jim, we're the Judiciary Committee, so we don't get to ask all these ag questions that much. So we're actually really intrigued by ag right now.
Well, thank you, Mr. Chairman and Representative Washut. It's a combination of two factors. You're very correct on one of them. We don't produce a lot of corn, which is a primary grain used for finishing cattle. And historically, it's been deemed cheaper to move the cattle to where the corn is than to ship the corn to where the cattle are. And climate factors, our more severe winters than that here are somewhat of a factor as well. But there's a second increasingly important factor that lies behind that, and that is the fact that we lack processing capacity in the state. So any volume of cattle here has to go elsewhere to be processed because we don't have, but we've got some excellent small meat processing facilities in the state, but we can't do anything on a volume to meet demand at the interstate or export market level. So that's another reason that the animals were going to have to leave the state at some point anyway, and they just as well leave and be finished elsewhere. That's why so much of our focus and a couple of bills that you've been dealing with in this session are targeted toward getting some larger meat processing in the state. And I think that, today we actually finish on corn or other grains about average of 75,000 head of cattle a year in Wyoming, out of nearly 1 million head of cattle that we have in the state. If we had the processing, it's been my estimation that in spite of not having the corn, we could likely double that number over a short period of time if we knew that the animals were going to be processed in Wyoming and that the beef could be marketed as a Wyoming branded product.
Very helpful. Thank you, sir.
All right. Jim and Amy, you made my day. I need to spend more time with the Agriculture Committee. I think it's the most exciting part of my day, I think.
We would welcome you to the committee, Mr.
All right.
Chairman.
Maybe I'll become an honorary member. All right. Any other questions? No. Committee? Thank you. Anyone else in the virtual world, Donna?
No, Mr. Chairman, that's everyone.
And the in-person world? I see. All right. Okay. Well, I guess I'll close public comment on this bill. Moved by Representative Washut and seconded by Representative Yen. Amendment on the bill. Representative Crago.
Mr. Chairman, actually, I'm not going to move an amendment at this time. I may have a discussion with the senator offline and determine whether it's really necessary. And I don't want to harm the bill. The bill isn't too important to me and obviously the sponsor. And so at this point, I'm not sure that, the wording's that big of a deal. If we can avoid having to send it back to the other side and not have any ramifications from that word. So at this point, I'll just wait and maybe have a discussion with the AG's office and with the senator and just determine whether it's necessary or not. Thank you.
I like that plan. We'll figure out whether we need it or not and take it up on a reading. Representative Larson.
Mr. Chairman, may I ask a question to the bringer of the bill?
Sure.
All righty. I was reluctant to vote for this, but hearing from the livestock growers is important. I guess my question is, do you see in any businesses inside the state that will be affected by this? Is that a worry? From their point. of view?
Senator?
Mr. Chairman, I don't believe that there's any business large enough in Wyoming that could manipulate the market in the way that we're talking about. So no, I don't think any Wyoming businesses would be affected by the power of the Attorney General coming after them. I also don't think that it's probably good practice or significant use of their resources. This is really intended to target business leaders that have an ability to manipulate an entire economic system, like the 4 big meat packers who dominate 80%, right? So will it impact Wyoming business? 100% in the right direction so that they have a meaningful ability to sell their products.
Okay. Further, is that, you good with that, Representative Larson? All right, further questions or comments? Representative Oakley?
Thank you, Mr. Chair. I just would like to say, in discussion on the bill, I'm certainly in for the bill, and kind of reiterating something that I heard Mr. McGagna say. I know 2015 was mentioned as maybe a beginning, but I think this is a fairly extensive, complex scheme, and my belief of it and some knowledge of it, having maybe worked for one of the big 4. I believe that there's certainly some information out there that the laying of this framework predates 2015, and we might be dealing with, quite a monster. So I think this moves it in the right direction. I appreciate seeing Wyoming being a part of that. So just on and support, I'll be a yes. Thank you.
Thank you, Representative Oakley. Did your hand go up, Representative Craigo?
Yes, privilege, Mr. Chairman.
Sure.
A little off the topic, but
Okay.
on topic at the same time.
You
So
got 30 minutes, so
my
talk about whatever you
my
want.
eldest daughter is giving a speech at the state FFA convention or contest actually Monday on this very topic. So oddly enough, she's asked me when I was in FFA, what did I give my speech on? And I said, the monopoly of the Packers, and that was like 27 years ago.
Huh.
Just so you know.
You need to make sure your daughter's here on Monday. See this bill on general file. That'd be fun for her, or here on Zoom anyway.
So
Yeah. You want to come in, you want to join the House committee, Senator Nethercott?
I do.
Representative Washit?
Thank you, Mr. Chair. There's some members of my family on my wife's side that are cattle producers, and we've had these conversations, around the dinner table a time or two about why their prices are so low, but the prices in the grocery store are so high. And I am very pleased that both the executive branch and the bringer of this bill have paid attention to this, and hopefully we can find some positive resolution.
All right. Anyone else? Got any stories to share? Nope. Move the bill. Well, you already did, but you want the question now. Okay. Okay, will you call the roll on Senate File 124, defending Wyoming business, trade, and commerce amendments?
Representative Craigo,
Aye.
Representative Larson.
Aye.
Representative Oakley,
Aye.
Representative Provenza,
Aye.
Representative Wilson. Williams, I'm sorry, Williams, excused.
Well, do you have a vote sheet? Okay,
I don't have a vote sheet for her.
okay. Excused is the vote, I suppose.
Vice Chairman Washit,
Aye.
Representative Yin,
Aye.
Representative Swanitzer voted aye. Chairman Olson.
Aye.
Thank you. Mr. Chairman, you have 8 ayes and 1 excused.
Great. And so Senator Nethercott, I don't know if you're familiar with this, but we have an old country lawyer in the House, Representative Greer. And we have a new country lawyer, Representative Crago. So Representative Crago serendipitously is going to, he's going to be the chief manager of your bill on the floor. I think he's perfect for it.
Thank you.
Yeah, I'm sure he'll help along, but yep. All right, Senator Nethercott, thank you for joining us.